So that's our just broad general introduction to the themes of communication law. What about intellectual property law? So if you've had an IP class, this will be familiar to you. If you haven't, you've heard a little bit about this in the Internet Law module, but just as a refresher, the areas that I have up here on the screen, patent, trademark, trade secret, copyright, are traditionally thought of as kind of the broad areas that comprise intellectual property. So a patent, really a utility patent, is a way of having an exclusive right over an invention. The basic requirement is that it's new, useful, and non-obvious. There you have to file a specific form of document and make certain disclosures to the patent office. The disclosures you make are examined against the prior art, against the universe as defined by the statute of what has come before, and you have to show that you've really done something different. You've done something new. You've done something that wouldn't have been obvious to a person of ordinary skill in the art, and then it's defined by the patent claims. So in a sense, a patent is very formalistic. A trademark is a name, word, symbol, or device that identifies the source of goods or services, and it goes with the goodwill of the entity that is selling those goods or services or distributing those goods or services. In the United States, you acquire trademark rights through use of the mark in commerce, and you can formalize those rights through a federal registration. In most of the world, you acquire trademark rights initially through registration, and then generally you have to use in commerce to keep the rights. In any event, the trademark rights are about goodwill, about brand names, and we looked at trademarks as they intersect with Internet law in some degree of detail in the Internet law class when we did domain names. A trade secret is something that has something that is kept secret or confidential, and that has economic value in virtue of being secret or confidential. Now, we usually think of something like, the secret recipe for Coca-Cola or something like that. So a formula certainly can be a trade secret, but it can be much broader. It can be confidential information that is, say, a pricing list, a customer list, things like that aren't broadly known or knowable. And then the last piece here is copyright. Now, I put copyright last on this list because really I think for most of what we're talking about in this class, in this new media law class, copyright is really the main body of intellectual property law that's going to be really important, and that's going to have some unique ways of interfacing with communications law. Certainly, there are patents that relate to new media. We looked a little bit in Internet law at some patent issues, like we looked at the Clear Correct case, which involves the transmission of a patent that covers the transmission of certain kinds of data, and whether that transmitted internationally gives jurisdiction in the International Trade Commission, some things like that. There are patents on basic technologies, but it's really not the focus of what we're doing in this class. Trademarks as well can be very important. Certainly in media industries, a brand for something like, say, a series of films like Lord of the Rings, a brand name, the title of a single film generally cannot function as a trademark, but the title of a series maybe can function as a trademark. That can be important. But again, it's not really the main focus of this class. Trade secrets, there could be trade secrets underlying products or services that people are making available online, but it's not so much, I don't think, a media issue. The real issues in media are copyright. So what does copyright do? Copyright under U.S. law allows certain sorts of exclusive rights over original expression that is fixed in some tangible medium of expression. The exclusive rights are set out in the Copyright Act, and they include things like reproduction, that is copying, distribution, to a certain degree transmission, as I'll talk about in just a moment, display, performance of certain kinds of works. When we talk about an original work, the standard of originality under U.S. copyright law is very, very low. All it requires, it doesn't require that it be new, it doesn't require that it be novel, it doesn't even require that it be non-obvious. All it requires is that it have some degree of creativity from the claimed author of the work. What is the appropriate degree of creativity? There's no way to define that for sure, but one way to do it is to sort of look at case law. There's a famous case called Feist versus Rural Telephone from the U.S. Supreme Court, in which the court said, well, a white pages phone directory listed alphabetically, if you remember physical phone directories, the white pages listed alphabetically, that's not enough. That's an obvious thing. It's so obvious. It's really not just obvious, but it's the only way to do it as a practical matter. Well, if it's the only way to do it as a practical matter, or if it's just factual, and it's just a set of individual facts, that's not enough. But if there's anything beyond that, it's going to be enough. So it's really easy to obtain copyright under U.S. law and under copyright law pretty much most places in the world, because copyright law is very much coordinated under some international treaties, that some of which go all the way back to the 19th century. So it's easy to obtain a copyright. It's actually hard to identify works that might be subject to somebody else's copyright sometimes, because there's really not a way to have a meaningful central registry of copyrighted works. You can do that with a patent because you have a specific set of claims. Even then, it's kind of hard to do, but you have a document with a specific set of claims. Copyright, it's impossible to do. So the right is very broad. It can be difficult to identify and clear the right. That creates all kinds of problems with enforcement. And it also creates all kinds of problems for intermediaries who might be making copyrighted material available to others, even if they didn't create the material themselves. That's a significant overlap with communications law, because it is the intermediary, the communication provider, making the material available. If they're distributing it, if in some cases they're transmitting it, if in making it available they're reproducing it, or if they're even facilitating infringement, that could be an act of primary or secondary liability infringement by that communications entity. So if we want to kind of manage this, we might have to have some kind of safe harbors and exemptions for the communications entity. Well, here's where we get to a few of these areas of intersection between communications and intellectual property law. So the first broad area is the Copyright Act of 1976 as it relates to cable television. And I gave you an excerpt from the Supreme Court's Aereo decision that gives a nice discussion of that background. So the Copyright Act of 1976 amended the Copyright Act of 1909, which was the primary copyright statute in the U.S. before the 76 Act. Now, it did a lot of things substantively to copyright law to bring the U.S. more fully into compliance with an international treaty called the Berne Convention. It dealt with, it changed the nature of the term of copyright, it changed the way copyrights are acquired, and those were huge, important changes. In addition to that, the Copyright Act of 1976 dealt with a problem that had arisen relating to cable television. And as you see in the Aereo case, the way cable television first worked, the very earliest versions of cable television, was that in some local communities where it was difficult for individual households to basically to get good television reception from over-the-air broadcasts, a large community antenna would be set up. That large community antenna, or it could be in an apartment building or something like that, and the community antenna would take the over-the-air broadcasts and then would distribute the over-the-air broadcasts through wire to the individual television sets. Those were the very early rudimentary cable systems, and they developed into kind of bigger systems. And the issue that was litigated then was, were those community television systems infringing copyright by improperly distributing copyrighted broadcast television works? And for a number of reasons, the courts all the way up through the Supreme Court decided that no, those community cable television systems were not infringing copyright. They were not technically distributing improperly under the Copyright Act. Well, the broadcast companies, of course, didn't like this, and so they argued that the act of retransmitting broadcast television should be deemed an act of copyright infringement. And in fact, that's part of what the 1976 revision to the Copyright Act says. So it adds a transmission right, and it says that the retransmission of something like a broadcast signal is an act of copyright infringement. Well, if that's the case, how do we still have cable television today? Because there was a compromise in the statute. And you'll see this often in copyright law, where there's a new technology, a new business model, a very important or potentially important new market that is causing disruption in the industry and that's causing conflict with the existing copyright doctrine. Sometimes the statute will be changed to create a right that governs the new technology, but then to create a statutory licensing mechanism. So what happens in the 76 Act is that if you qualify as a cable television provider, and you fit that definition and qualify as it, and there's an interface here with the FCC regulation of cable television, then it's not an act of infringement to transmit if you are paying a statutory license or royalty. So it's not a pure market mechanism. It's not left to just kind of willy-nilly or piecemeal, I should say, the market deciding, but the government is regulating the way the market develops, and it's regulating the kind of royalty that the broadcasters get. A fairly common kind of solution under copyright law. But it defined very particularly what a cable television company is. And then there are other developments of it that relate to satellite television. That issue, as we will see, as we read more of the Aereo case and other cases around it, is becoming really hot and important today. I think it's one of the most important areas of new media law today. Because the question is, outside of something that's clearly a traditional cable television company, like Comcast or something, when is internet-enabled television a violation of the Copyright Act? Or when is an internet-enabled sort of television provider actually functioning as a cable television company entitled to the same kind of statutory license? Or when is it not a transmission at all and therefore not infringing? Those are really important areas that relate to this question of convergence, because this is a place where the law is really impacting control over the new ways in which the medium is being used. Okay, I have up here the Digital Performance Rights and Sound Recording Act of 1995. I gave you a nice little article summarizing some of the provisions of that. We'll talk about it a little bit more when we talk about the law of digital music. But this is dealing with the ability of a holder of rights in a sound recording to obtain some kind of royalty for the performance, the playing of that sound recording digitally. And it relates to the previous way in which there were not rights for the holders of a sound recording right to obtain performance rights for the playing of the song of the recording over broadcast radio. I'll talk more about that when we talk about digital music. And then finally, the Digital Millennium Copyright Act in 1998, and we will spend at least two classes talking in a lot of detail about the DMCA. Briefly, what does the DMCA do? Well, I mentioned that issue with a communications infrastructure provider potentially being liable for copyright infringement for materials that are transmitted over their system, either directly liable or secondarily liable. And if you're a media provider, if you're a record company, you might want that because it's very hard to track down and really have any meaningful impact on individual, a mass multitude of maybe millions of individual infringers. It's much easier to have a large single entity, a Comcast, for example, to be able to go after. But if, from the policy perspective, certainly if you're the Comcast, you don't want that. And from the policy perspective, you might say, well, I'm not sure we want that because really we want the infrastructure just to be kind of dumb infrastructure. We want it to not discriminate as to content. And so we want to have a safe harbor. So what's a compromise there? We'll see when we look at the DMCA. It attempts a compromise by allowing the owner of an intellectual property right, a copyrighted work, to notify the internet service provider, and then requires the internet service provider to have a policy where they then take that content down. And then there is some kind of opportunity for the person who put the content up in the first place to contest that notice. And all of this, at least at some point, short of infringement litigation. We will talk about this in a lot of detail. There are some particular parts of it, like what really constitutes notice that they're infringing works. When is it that there's so much pervasive infringement that there should be some kind of constructive or what's called red flag notice? Are copyright holders abusing this by sending too many takedown notices? Do the copyright holders have to take into account the question of fair use before they send in those? A variety of things like that that have been litigated and are being litigated as we speak, that are really fundamentally important for this area. So this is our basic overview: convergence, background of communication law, background of IP law, the intersection of communication and IP law, and those are the topics that we'll continue to be talking about throughout the semester. So this is the end of the lecture, and I will see you at our in-person meeting on Thursday.